Welcome back to the Fox Robbins Business Show. Come on in, step on in. The Fox Robbins Business Show is all about developing and encouraging your best business ideas. And I'm the co-host, Bill Fox. The other co-host, though, this guy is amazing. He is irresistible.
I thank you.
Many people have said that.
I think you're cute.
Some have not.
I think you're cute too.
He's exemplary, and he's incorruptible.
That happens to be true.
Coach Robbins.
Thank you.
And
I understood those 3 words.
we're doing some special work. I consider special, very valuable work with Douglas E. Denninger. He's an attorney and a patent attorney. He's been practicing for a long time, and he knows everything there is to know about the patenting and protection of intellectual property.
But you were afraid to ask.
And this is episode 2. Make sure if you see this, also see episode number 1, because it's all of a piece. And Doug, great to have you on the show.
Bill, thank you.
We're talking about types of intellectual property. We also have our disclaimer that this episode of Fox Robbins contains only generalized information. It's not intended specifically as legal advice or a complete discussion of legal issues. But let's go on. I want to jump in to this display, Doug, on copyright and works of authorship, and jump into the rights on copyright.
That's right, because as we discussed during the first section, patents allow you to stop others from making, using, or selling your invention. Copyright, after you come up with your written work, you've come up with a graphic, a new piece of art, a sculpture, song, dance, all that's copyrightable. What you can do is protect other people from copying you. They change it enough and they get their own original work. One of the unique things about copyright is if there are 2 people that independently come up with something and you have another original author, they can actually get their own copyright and proceed in spite of your copyright, because you are, they didn't derive it from you. So copyright, as we'll talk about, has some very broad protection as long as you put the copyright notice on it. Little C with the circle. That C with the circle is important.
There it is, yeah.
And you want to have the word copyright ideally as well. But you will protect people from direct downloads and copying. They change it enough and then they have their own work.
And you do this with the state or with the government? I see you got copyright.gov there.
That's right. Trademarks can be either state or federal. Patents are federal. All the United States, USPTO.gov. Copyrights are with the Library of Congress.
Okay, so it is
federal, but a different place, the Library of Congress.
Right.
Copyright.gov.
But it is all 50 states.
That's right.
Okay.
That's right.
Aren't you impressed? I got the C in here, man.
Well, thank you very much. I appreciate it. Where's the R?
We'll get to that.
Thank you.
Trademarks, Doug. We want you to talk about trademarks. TM, source of goods and services, and start with your first item is fanciful / arbitrary.
That's right. Well, when you're coming up with a trademark, you'd like it to be memorable and different. Those are the gradients for protection. The strongest protection you'll get is something fanciful or arbitrary. Whoever was clever enough to put that little apple on a computer, apples are fruit, right? But now everyone knows that apple refers to these great technological,
with the bite out of it.
With the bite, which actually made it especially protectable, because they've, getting to copyright, the more you have something different, the more copyrightable it is. With trademark, the more recognizable to customers and consumers. The whole point of trademarks is to identify the source of your products and services. products are called goods, physical things or services,
yeah.
what you have to offer.
Consulting.
That's right, consulting, legal services,
Right.
financial.
Right.
So if you have that strange name, Exxon, that's being used for, it's just a made-up name that meaning became associated with petroleum products through Exxon.
Enron. No.
No, that's a separate topic. So suggestive is maybe not quite as strong, but it kind of hints at what you're doing. We've worked with an entrepreneur, Andy Kogut, and he has a utility patent on his product that goes in the folding tailgate.
Right.
And you pull it out and use it to retrieve products.
Right.
And he has a registered name, Tailhook. Tail for tailgate, hook because you can retrieve things. But it suggests, but it's not descriptive, which is, makes it protectable. He has a registered trademark on Tailhook for
Right.
that. What you offer as a product or service is important because the same name can be used to represent different things. Cadillac can be dog food, Cadillac can be a car.
Right.
You don't expect the maker of the car to provide your pet food. So
Usually not. Yeah.
that's right. So the Cadillac dog food can coexist with the Cadillac automobile. Tailhook, there are registered trademarks on organizations of Navy pilots. The tailhook, for landing on the carrier.
That's where the tail hook comes from.
That's right.
originally.
But Andy Kogut has tailhook for his
device
tool,
that goes in the
which
tail
is different.
of a trunk, right.
Trademarks are protected by classification, and goods are 1 through 34, and services 35 through 42 or so,
Right.
and different categories or classifications, and you can have the same name for different services or products. Ultimate test, is there any confusion?
Right.
Descriptive is generally not protectable off the bat. For trademark registration, there's the primary register, that's the best. There's also a secondary. So even if you can't get protection under the normal primary trademark registration procedure, you can get a secondary registration and then wait until you develop some customer recognition. You get that secondary meaning.
Right.
Then you can come back and
You come back around, yeah, like you
reapply.
said, dog food and cars. Right.
That's right, that's right. Generic is not protectable at all.
Right.
There's some great examples of names that started out really arbitrary and fanciful, cellophane for plastic wrap.
Right.
But if you use it in a generic way, use it as a noun, you'll lose protection. Escalator for moving stairs. Aspirin has been lost.
Aspirin, Bayer, yeah.
That's right, that's right. So you want to make sure that you use your trademark as an adjutive.
Well, what are Kleenexes? Are the same as a,
Yeah,
or Xerox?
Exactly.
copy.
Xerox copy.
Exactly,
yeah.
exactly. When you're big enough and strong enough, you can withstand that. You talk about Googling something, everyone knows you're referring to doing a search.
Google.
Using
It's a verb now.
That's right, that's right. But if you look initially when you're starting off, your trademark is the adjective and you have a generic name, the Kleenex tissues.
Right.
The Google searching.
Right.
So you can't protect generic, it's got to be different. The more different, the better.
Okay. We're going to continue with you on trademarks.
I got a funny story for you. All my students, in the undergraduate class at the university are, 19, 20, 21. I asked them, what's Amazon? They said, that's an online. I said, you people know it's a river? A lot of them don't even know it's a river.
That's right, that's right.
Amazon, it's trademarked,
Highly, highly recognized.
Yeah.
But trademarks are like muscles. The more you use them, the stronger they
yep.
get. So
Right.
you want to make sure that you put that little TM there,
Yep.
and you use it prominently, and you're using it as the adjective rather than as a noun.
As a noun, right.
And filing, as we discussed first time, can be by state by state,
Yep.
or one-stop shopping, uspto.gov. You
Right.
get nationwide
Come on.
protection.
Right.
There's also international filing under different things. With patents, you had the PCT, Patent Cooperation Treaty.
Yep.
There's this Madrid protocol you can file under, and that gets protections. You have to identify and select. Through one filing, you can designate different countries, and that has to be done within 6 months
Okay.
if you want to obtain your priority date. So there's no hard and fast time you have to file. In fact, you can even file before you start using a trademark. If you're actually using it, you can do an actual use basis. If you just want to reserve it, it's an intent to use, the ITU.
Right.
Intent to use is a way to file an application as a placeholder so no one scoops you as you're getting your materials ready,
Right.
you're gearing up to commercialize. So once you have a name, you can do searching to make sure you have some idea with it's there, and uspto.gov under the trademark section, there's patents, trademarks, go under trademarks, and there's a search test.
Yeah.
There's a certain kind of searching, basic and advanced. Do a basic search and look and see what's been done. And before you make a decision, of course, talk to a professional, because the spelling is probably not going to make a difference. If you spell it with a Y or an I, that's probably not going to help you, because if it sounds the same when you pronounce it, think radio ads or people who just close their eyes when they're listening to your show.
Right.
What does it sound like? You want to
Right.
have a different sound in order to be protectable as a trademark, not just the spelling.
Do you know the name that Jeff Bezos wanted to call Amazon originally?
What?
Cadabra.
Cadabra.
You know, his lawyer said, sounds too much like cadaver.
Yeah, yeah.
Okay, we'll do Amazon.
Another challenge is what's it going to sound like in French or
Yeah.
when you translate it, you go into other countries. So
Well,
That's where that Exxon came from, by the way, Exxon is supposed to be meaningless. That's the purpose.
right.
I think they spent a huge amount of money for a team to find a name for that oil company, or whatever, energy company.
Well, it was
that would not be could go to Africa or Europe or Middle East or Far East or wherever and be meaningless and not insult anyone.
That's right.
Chevy started selling their Chevy Nova in Argentina many years ago, and they were wondering why it wasn't selling. And then they realized, well, Nova means no go in Spanish, so that was a little bit of a faux pas.
exactly, exactly.
Or the toilet paper that the German company tried to sell in England, but nobody would buy it. KRAPP, toilet paper. It just didn't go.
Yeah, no, you want to know that your product is
You can't make this stuff up. I've got
That's
a
right.
book that tells me this.
Absolutely, absolutely.
On trademarks, you identify
Right?
and use. What's this? Use TM as an adjective.
That's right. So you're using your trademark as an adjective, your Kleenex tissue, and until you get your registration, use the TM.
Yeah.
And the good things about copyright and trademarks is that you can start identifying it before you file.
Right.
With patents, it's got to be filed with the USPTO before you can say patent pending. You have to take those steps. TM, go ahead and use.
Put it right on. Prior
Copyright, go ahead and use.
I'm claiming, right.
That's right. So that shows just to the world that you consider it your trademark. Then you can take the steps to exclude others from also using it.
Right.
All right, and then trade name / company name.
Right. This is a tricky thing, and that's the same name can, in some circumstances, refer to the company, and other circumstances, their product.
The brand, yeah.
Right. So DuPont. When you say DuPont, that's a shorthand for E.I. DuPont de Nemours and Company.
Yeah.
Right.
When you say Coke, you may be thinking of the Coca-Cola Company, or is it a Coke product, or is it the DuPont Stainmaster carpet?
Right.
DuPont is the house brand. It shows that it's a DuPont product.
Right.
Stainmaster for the particular trademark they have for this carpet,
Right.
and carpet's the general name. So you can have several trademarks in a row, if you will. Your house, DuPont, your specific Stainmaster, and then your noun, carpet. So what hierarchy do you want to get?
Right.
You know, use your main brand as your trademark, or maybe develop some sub-brands.
I ask my students also, do any of you drink a beverage from Boston Beer? And they, no, never heard of it. How about Sam Adams? That's the brand, that's what's trademarked, right? Boston
Absolutely.
Beer is the corporation.
Absolutely. Sam Adams, just briefly, Bill, reminds me of abbreviations. Federal Express had their full name registered, and then it became FedEx.
That's what people called it.
That's right. So
They changed it.
Samuel Adams, Sam Adams. So
Right.
you may think also about if it's truncated, you know, do you protect that truncated
Better
form
protect
as
what
well?
the market's calling it.
Exactly.
You can call me anything you want if you give me your money.
Furthermore, further on trademarks, Doug, is you mentioned searching here. You can search.
That's right. That's the website, uspto.gov, under the trademark section, under searching, tests, and then it'll be basic. And those are things you can do yourself, but there are some pitfalls for the unwary or those that haven't done this before. So, you know, first pass is good, but then do go for your professional advice before.
That's how I tell
proceeding.
people, go in there, take a quick look. You know, do what you can, but don't trust it all, because that's not your business. Your business is doing this other thing. Once it looks like it may be okay, get a hold of a patent attorney and get it done right.
Yeah, you're on your highway to protection,
Right.
But you know there are exits.
That's right, and you're not there yet.
Yeah, and you know maybe you can take yourself off at an exit, but that doesn't mean you can still keep going without consequence.
And detailed, CompuMark.com, what's that?
That's right. There's search services. One of them is can be seen at CompuMark.com, and your intellectual property attorney will probably work with someone if you want more certainty. Searching is optional, both for patents and trademarks. How much certainty do you want that you can actually use this going forward? If you haven't invested a lot in making up promotional material and product with this name stamped on it, if you can change things easily, maybe just file it first and see what the trademark examiner finds. But if you want to know for sure you have it, then you need to do some additional
do it up front,
There
searching.
are links, Doug, that you mentioned. There are links into Adler Pollock. What's that?
That's right. INTA is the International Trademark Association, and they have a section with some very helpful primers on trademarks. So INTA.org for the trademark primers. Many law firms like Adler, Pollock, and Sheehan have helpful instructional videos and papers and such. So many firms will give you free educational material, and by all means take advantage of it.
And Ma TMs.
Well, right, that's the mass TMs. You can do searching not only federal but also your state, depending on what level of protection you're looking for.
Okay, we're going to move on to trade secrets.
Right.
Proprietary information, NDA, starting with NDAs. What do you mean by that?
Well, let me first just identify trade secret as something that you think is proprietary that's not generally known to others. As we'll see, you have to take active steps. You have to take active steps to protect it. And one of those steps is the NDA, non-disclosure agreement.
Right.
So before you actually show your trade secret to someone, that has to be under confidentiality.
Right.
For those that don't want to get limited by that, you mentioned VCs and angel groups and others, they're exposed to so many things. They say, we don't want to be risk contamination. So, take some step to protect it first. Well, with patents, you can file first.
Right.
With trade secrets, you just can't tell them until you do some kind of NDA or whatever.
Right.
So talk about it in a general way.
Right.
You have a black box, you can kind of tell them the results, but don't tell them how it works.
Yeah, here's what happens.
Yeah.
How do you do it? That's a trade secret. We'll sign an NDA, I'll tell you.
That's right.
There's NDA for, you mentioned here, it's for consulting and for employment.
That many times employees will be exposed to the confidential information, the proprietary information of their companies, and you want to make sure that as an employer, you've got the right written documents in place showing that everyone who's exposed to this, be they employees with the employment agreement or contractors and consultants with a consulting agreement, or particular NDA if you want to show them something. So it's steps to take, and it's like a fence. You know, the more you not only have the pickets, you got the barbed wire on top. You know, the more secure it is. Put the concrete base.
Yeah, the metaphor I use. Okay, you've built your castle. Now put a wall around that castle. You want to take the next step. Put a moat around that wall.
Right.
Want to go further? Get some piranha and some alligators. So each step you take gives you another layer of protection.
Yeah, be that with different kinds of
Right.
types of protection, or different contracts.
Absolutely.
Consulting agreements, NDAs, and
Right.
Other contracts.
Right.
Further, continuing on trade secrets, Doug, proprietary information, there are procedures that you've given us, you know, to keep procedures to keep secret.
Right. If you want to show that it is in fact secret, if an employee leaves and illegally describes it to someone else, you want to show that it's a protectable secret.
Right.
So then you can sanction that employee. If they've gone to a competitor, perhaps the competitor has to, you know, stop making that product, or they need to isolate that person so they're not working in the same area. But
Right.
you have to take those active steps.
You got to show that you tried to protect it internally.
That's right. So you've got sign-in sheets to show who's coming into your company.
Right.
You've got some extremes. It's a legend, I guess, about how the steps that W.L. Gore takes. If you want to go into, you know, Gore-Tex and other
Yeah.
things, nice trademark.
Right.
But if you want to see their shop, they have a rolling shower curtain that they'll put you in. They come in as a visitor, they'll put that curtain around you, and then they'll guide you through the shop so you can't see what's being done till you come to your little section that
You
you
see
brought in
what they
to
wanna
consult.
show you.
They part the curtains, you work there, close the curtains, and they take you out. So active steps to protect,
Right.
passwords, a dedicated space that limits access,
Right.
you know, shower curtains if needed.
Shower curtains. Cool.
And one thing, talking about secrets, I don't know about you guys, but I went to work for a company, and they said, here's this, you know, non-disclosure agreement. Here's a non-compete agreement, you know, and so anything that you learn here, you can't take elsewhere, and so forth. I said, wait a minute. You're hiring me because I'm bringing secrets to you. Not secrets, but I mean my accumulated knowledge. I'm not a kid out of college. I'm experienced.
Yeah, and so many.
I have information, but that's why you want me, that I'm bringing to you. You ought to sign an agreement with me. You should have seen, you know, this, you get this kind of reaction.
Well, many times with an employer, you should document what you have. If you have an issued patent, it's clear.
Right.
But if you have something you've developed, maybe list it as something you have before you
prior
join
to
them.
you,
So
prior
you
to
already
coming, right.
came up with it prior. You know, it's old invention, not something new you did
Right.
with them. And just one more thing, non-compete is a little different from the non-disclosure.
Yeah.
Non-compete controls. It kind of stops you for a definite period of time, 6 months or a year, from working in the same field.
Some, maybe even a geographical area.
Right.
And a certain, like say, 2 years within 50 miles or something like that. Right?
That's right,
Yeah.
for that, in that field.
Right, in that field, right.
That's right. So before you sign any of those, again, talk to a professional before you commit yourself and see, does it have enough constraints on it to make it reasonable?
Right.
One thing, before we finish up, I wanted to talk to you about is patents or trade, not patents particularly. I'm thinking about is that those of you who want to get a patent, if you have it in mind and say, "Oh, I got a patent, I'm totally protected," you know what you got? Nothing. There's a lot of vicious people out there who, you know, would just darn right just copy whatever you're doing, and blatantly would copy and say, well, you know, sue me if you feel like it. I mean, you've got you have a piece of paper that says I have a unique idea, but that's all you've got. I remember it was a story about the guy who invented a bona fide inventor, invented was it a windshield or
The
windshield?
the intermittent windshield.
Intermittent windshield,
Yeah.
and Ford used it. They didn't pay him, dime one, but I think if my memory serves, it took him 17 years
Yep.
in the court system to enforce that. And he did that. I think he did carry it through.
He did, and it's up to you. What you're saying is it's up to you to defend it. The government's not going to step in. They're not going to send the Marines in. You've got to sit down with your attorney, your legal folks, and say, I want to stop these people from doing it. It's up to you to defend
But
it.
you can start it with a cease and desist letter.
Right.
So it doesn't have to be a commitment to a
No.
huge amount of money.
Just warning them.
Just warn them, and for many people, that's
Shot across their bow, I call it.
you found me. You see what I'm doing? Okay,
Sorry.
I'll stop. Yep,
Yeah.
that's right.
Right. So I'm just bringing it up that you applied for the patent. You have a patent. You think you're all taken care of. You still could have grave difficulties ahead, and you have no doubt you have clients who have had where the protecting the patent turns out to be very difficult and
Sure,
inexpensive.
but even though it's expensive, you can get that white knight to work with you. So maybe you want to go after Ford. Well, talk to a GM.
Right.
Maybe there's someone else you can get behind you.
In your corner, right?
That's right. Because you can also there's selling or licensing. Licensing, exclusive or non-exclusive. And if you exclusive license, that's almost as good as selling because it's enforceable, and then you can get others to do that protecting for you.
Right.
Great. Doug, thank you for being on Fox Robbins. I
pleasure.
reserve the right to recall the witness.
I appreciate that. Thank you.
We
He's
need
the
you back
judge.
because we've covered a huge amount
You're
of ground.
still under oath.
We've covered a lot of ground very fast here, but we're gonna have to, come back and, and maybe, focus in on things that are important to those who are either starting a business or have an existing business and need to think about, protection and so forth. So
Happy to
thank
do
you.
Pleasure. Thank
See
you.
Dougie, good to see you, my
And
friend.
thank you guys for being on Fox Robbins. And we upload the Fox Robbins to YouTube, and so you can see it anytime at your convenience. Go to YouTube, go to the search box and just type in one single word, Fox Robbins, FOXROBBINS, and go to the library and pick topics that are of specific interest to you. And thank you. We'll see you guys next time.